Hello. This is very much an introductory and preliminary lecture in a series that, hey, excuse my voice, and I'm in a bad way, but ignore it. A series that's going to go on throughout this semester and into the spring, and there'll be various experts with lots of firm convictions talking to you. I want to introduce the subjects, and I'm going to leave quite a lot of time for your participation, in part to hear what you would like to have clarified, what you think needs to be better understood. Elections, this is what we're getting into the election season. It starts earlier and earlier. Elections are what may be called the festival of democracy, in which it announces, celebrates, and enacts itself. No democracy without elections. The connection is not quite one of the identity. In a very small community, there may be universal direct participation by all those who count as members in all significant decisions. And it works the other way, as in the most famous instance of the 1933 election that promoted Hitler to supreme and dictatorial authority in Germany. An election, though perhaps democratic in itself, may lead directly to and embody the choice of the complete abandonment of democracy. So as to what democracy is, let us start with Lincoln's words: government of the people, by the people, for the people. This connects with, though it's not quite identical with, the notion that democracy is self-government. This is nicely captured in the first provision of the French Declaration of the Rights of Man and of the Citizen, right after the Revolution, the authors of which were greatly influenced by the American Declaration of Independence and the Virginia Declaration of Rights. This is what they wrote. Law is the expression of the general will, Rousseau. Every citizen has a right to participate personally or through his representative in its foundation. And then later on, the Declaration goes on to say, all citizens have the right to decide, either personally or by their representatives, as to the necessity of the public contribution, taxes, and to grant this freely. That all means all is explicit in the Declaration of Independence's proclamation as a self-evident truth that all men are created equal. Once again, I turn to Lincoln, who in his debate with Douglas in 1858 issued this challenge. I adhere to the Declaration of Independence. If Judge Douglas and his friends are not willing to stand by it, let them come up and amend it. Let them make it read that all men are created equal except Negroes. Let us have it decided whether the Declaration of Independence in this blessed year of 1858 shall be thus amended. It is, however, a commonplace that in a society of any size and complexity, the first option, direct, universal, participatory democracy, is impracticable, and universal plebiscitary democracy is practicable only on special constitutional occasions. For the rest, we are inevitably remitted to representative democracy. And elections are the occasions on which we choose those representatives. It is through them that we are governed by representatives freely chosen by us, all so that we are governed by ourselves, self-government. Everyone who exercises authority over us ultimately traces that authority to some act of our chosen representatives. And that goes for judges, of course. That is why the Massachusetts Declaration of Rights, in Articles 5 and 6, written in 1780 by John Adams in his characteristically florid style, states, "All power residing originally in the people and being derived from them, several magistrates and officers of government vested with authority, whether legislative, executive, or judicial, are their substitutes and agents, and are at all times accountable to them. No man, nor corporation, or association of men have any other title to obtain advantages or particular and exclusive privileges distinct from those of the community than what arises from the consideration of services rendered to the public, and this title being in nature neither hereditary nor transmissible to children or descendants or relations by blood, the idea of a man born a magistrate, lawgiver, or judge is absurd and unnatural." John Adams had a son who was president also. I love this quotation in part because it is the only founding document which I know of that describes a contrary proposition as absurd. So there you have it, the connection between self-government, democracy, and elections, and the corollary that those elections must be elections by all, equally. Having reached that conclusion, why are we not at the end of our story? No need for this lecture series. Why do we indeed indeed, how can there legitimately even be laws about elections, election law in this democratic republic, the subject of this year-long series? The probing challenge has often been issued in the context of denouncing this or that particular provision of some election law. The idea is that election law is almost a contradiction in terms. I extrapolate from an argument that has been pressed in opposing all campaign finance regulation. In that context, it has been argued that by making rules about who can do and say what, when, with, and to whom, and at what cost to their own and their friends' pocketbooks, all that current legislators are doing is making it harder for the people to challenge them at the polls, harder to replace them. Campaign finance limitations are in truth nothing but incumbent protection schemes devised by those very same incumbents. In the course of these lectures, we will examine the factual basis for that claim. But for the moment, let's generalize it. Let's take it, in the phrase from Tom Lehrer's song, "Anything you can do, I can do meta," to the meta level. Since legislators are supposed to be chosen by the people, why should those same legislators be allowed to legislate, that is to say, set the rules by which we, the people, choose and may try to replace them? What does the Constitution say about this? Surprisingly little. Starting at the beginning, the preamble does say that this Constitution is ordained and established by we, the people of the United States. Article 1, Section 2 says that the House of Representatives shall be composed of members chosen every second year by the people of the several states. But who counts as the people of that state? That is in part up to that state. But that state cannot set the qualifications to be different from the qualifications that are used for the most numerous branch of the state legislature. So, if there are property qualifications for voting for the state legislatures, so may they be imposed on voting for members of the House of Representatives. The Constitution does set a minimum age, 25, for a representative, requires that chosen representatives be 7 years citizens of the United States and an inhabitant of the state. The qualification of senators after the 17th Amendment are the same, except that the minimum age is 30 and 9 years a citizen of the U.S. In this most crucial matter, therefore, the Constitution does not explicitly decree democracy, but rather assumes what is, and was certainly the case, that it is referring to states, all of which already have and will continue to have functioning elected legislatures. That is a matter of some importance, because here and at many other points, the Constitution does not decree or establish, but assumes the prior existence of governments, those of the states, all of which are assumed to have elected governments, executives and legislatures. Whatever democracy we have is built, therefore, on the platform of existing democracies. The closest the Constitution comes to speaking directly to this premise is in Article 4, Section 4, in which the Constitution guarantees to every state a republican form of government. That the guarantee is to the state and not to the people of the state gives this clause the flavor of a protection against violent imposition of some unelected government from within or without. And the mention of invasion and domestic violence confirms this. Of course, these presuppositions were, in a sense, quite correct. In most instances, the state governments were more explicitly, intensively, and enthusiastically democratic than the national government would be. Election of judges was instituted as early as 1812 in Georgia, and yet they imposed various restrictions on who shall choose their governments that today we judge undemocratic, a sentiment enacted in several amendments to the original document. Women were everywhere excluded as electors. Slaves were excluded in the slave states. Free persons of African descent in some states. In some states, property and other qualifications limited who may vote. And even democratic framers took this as self-evident. these pre-existing underlying state systems of democratic elections were incorporated by reference by Article 1, Section 2 and the 17th Amendment. Article 1, Section 4 incorporated by reference state legislatures' rules of time, place, and manner of holding election, although Congress has the power to override them. What counts as time, place, and manner has been the subject of some controversy, and I think the litigation that's going forward now in North Carolina about access of voters, voter ID, and various other voter control methods will bring that up, because there, North Carolina is exercising the constitutional right to set the time, place, and manner of holding elections. And Congress has not, but is being urged by many of the candidates to override such choices, as for instance with voter ID. Finally, the First Amendment's guarantee of freedom of speech, press, assembly, and petition sets important constraints on the authority of legislatures, federal and, after the Civil War, state, to restrict the people in elections. The 14th Amendment's guarantee of due process and equal protection, and the 15th Amendment's guarantee that the right to vote shall not be abridged on account of race. The 19th Amendment adds sex. The 24th adds failure to pay poll or other tax, and the 26th adds age. That is to say, citizens over 18. These constitutional provisions impose important constraints on the authority of government to regulate elections, but a great deal of authority is left. So the challenge raised in respect to campaign finance regulation, and now generalized to all kinds of regulations, remains to be answered. If government is by the people, what justifies any regulation by the government of the people when they choose their government? If we follow out the implication, I might say the innuendo, of that challenge, we arrive at the conclusion that the people's choice of their government must be completely unconstrained by that government, which, after all, is wholly dependent on them and which they are choosing. And that conclusion, of course, in John Adams' words, would be absurd. What would it even mean for an election not to be governed by any law at all? Who would get to vote? Children? Why not? But would their parents get to vote their ballots? Are certain classes of people disqualified? For instance, ex-convicts, people presently in prison? Some of these qualifications seem self-evident. Others are controversial, but they all imply a theory of democracy. Why, for instance, did women count in the census, but before 1920 did not have the constitutional right to vote? Who gets to go on the ballot? How many names are there to be on the ballot? How do you get on the ballot? What counts as winning? By and large, we have what's called a first-past-the-post system, where whoever gets the most votes, even though it's only a plurality, ask Bill Clinton, gets to win. In some states and in some situations, that isn't so, and the two top candidates have to endure a runoff. But none of that is recognized by the Constitution. That's all subject to law, to laws made by the legislature on what theory? If choosing members of a representative body, not just a single leader, how are the votes distributed? Single member or multi-member districts? How are these districts to be drawn? Here we get the issues of gerrymandering. All these matters the Constitution leaves open, and thus open to rules later to be made. But by whom? Who else but the legislatures themselves? Then there are the questions about organizing the actual election. Should the balloting be on one day or stretched out over a longer or shorter time? How should the candidates finance their campaigns? Should there be private or public financing? If public financing, who gets how much for what? If private, are there any limits? If limits, how much, on whom, for what? And once we have elected a legislature, what access should citizens have to it? Should contact with legislators be similarly regulated? This is the regulation of lobbying, and it is related to fundraising. Think for a minute why. Lobbyists as bagmen. Each of these questions has received multiple answers across this country, over time and among developed democracies. Some of them are implicated in sharply contested court battles just now. Campaign finance, certainly. Many will be discussed in the other lectures in this series. But there's a general point. Think of the general idea of a democracy and democratic elections. I hope I have shown that this is a very vague and insubstantial notion, a kind of fog of possibility, which must be brought into focus by a myriad of concrete, specific choices and institutions. It is like a hazy, unfocused cloud of indeterminate colors and indefinite shapes. The choices that must be made are like the twist of the lens that brings the vague cloud into focus, with images resolving into sharper forms. But the metaphor is faulty in this respect. The vague, out of focus image can be brought into many possible sharper images. And however you choose to bring one issue into focus, say the definition of possible voters, or the establishment of who and how many candidates there are to be on the ballot, the way in which all the other open questions must be brought into focus will change. So if you arrange the voters one way, the possible forms of legislature, though not necessarily fixed, will present a narrower range of possibilities which must themselves be brought into focus. And these will rearrange other choices and perhaps require adjusting previously chosen electoral shapes. In this respect, it is like constitutional interpretation generally. In the 20s and 30s of the last century, we had a newly focused conception of freedom of speech. When that concept was enlarged to include motion pictures and then sexually explicit material, the concept, though enlarged in one sense, required further refinements. Similarly, with the inclusion of speech that would previously have been unprotected as either defamatory or merely commercial, the earlier simple, clear, and present danger test would not do because it did not fit. And so it goes in respect to election law and the concept of democracy as well. We are engaged, in Wittgenstein's metaphor, in rebuilding the vessel of our democracy while we are at sea. Well, now I'm going to sit down. We've got microphones, and let's hear from you. Oh, come on. This is Harvard Law School. People aren't shy here. Yes. Good. Good for you.
So obviously we were talking mostly about the American model, but other nations clearly do different things. Some nations do have set limits to how much they finance a campaign and have different election laws. Do you think that there's a model that's preferable to the United States, or do you think that there's anything we can take from these other countries?
Could you bring that to bear on a little more for me?
I'm trying to think of good examples, but I can't think of any. I just know that some different countries, like India, just had one of the largest democratic elections in the world, well, the largest in world history. And they kind of had an more open process than what we have instead of the delegates and everything that we have. So I was just wondering if there's any examples that we see throughout the world that might be preferable to some of the models we have in the United States.
Well, that's a very important part of this inquiry, although I don't believe that any of the speakers that have been lined up, except maybe Professor Anzalabere in the second semester, is going to engage in that comparative discussion. I know in my seminar on this subject I will, because it's really very important. On campaign finance, the US is a complete outlier. And it's very interesting to see what happens in other countries, although do not get the impression that because we are an outlier, therefore the other countries have beautiful systems. I think of the fact that Jacques Chirac was, I believe, criminally prosecuted for campaign finance violations. Sarkozy investigated for money that he collected from the richest woman in France, who's the heiress to the L'Oreal fortune. Helmut Kohl, who is really the hero of modern Germany because he affected the reunification of the East and West, was forced out of office and really shamed because of campaign finance violations. Any number of British politicians have run afoul of campaign finance laws. So, we are not, we may not be better than anybody, but we're not worse. And it's well worth looking at this in a comparative perspective. Good. The ice is broken. You really ought to be congratulated.
You mentioned the election of Hitler, where a democratic group makes a decision that makes the group less democratic for the future. Do you think that that's a legitimately democratic choice that a group of people can make? Or do you think that it's inherently undemocratic for a group to remove their ability to make decisions?
Well, that's a deep question. It's a little bit like the question whether a constitutional amendment can be unconstitutional, which in our case, there are only two limitations. One of them is no longer in effect. The other is depriving any state of its equal representation in the Senate without its consent. That is unamendable. But can you have, it's a little bit like John Stuart Mill asking whether it is a proper exercise of liberty to sell yourself into slavery. Is it undemocratic? Well, is the notion of democracy a normative notion, or is it simply a definitional thing? And if the definition is any choice made by a majority, however constituted, of the people, then the answer is, yeah, that can be democratic. If it's normative, if the idea of democratic is somehow not just a description, but a badge of honor, then that decision, that kind of a decision, does not merit the badge of honor. Now, what can we say about that? I think you and I tend towards the second, but that's a legitimate subject of inquiry. And furthermore, if we admit the possibility that a democratic vote can, in this sense, be undemocratic, who decides that that is the case? Is that to be voted on democratically? It's an interesting thing, and somehow one doesn't hear about it very much. We have three branches of government: the legislative, the executive, and the judiciary. And somehow it is thought, well, yeah, but that can be a question for the judiciary. Interestingly enough, there was a constitution. It didn't, most unfortunately, it was not in force for very long, but it was established by a very great man, Sun Yat-sen, in the establishment of the First Chinese Republic. And that constitution had 5 branches: legislative, executive, judicial, examination branch, and election branch. The examination branch is very interesting. Going back through to Confucian times, the civil service, which was very important in China, was chosen by competitive examinations, mainly knowledge of the Chinese classics and so on, but competitive examinations. And therefore, the civil servants were usually enormously learned scholars, often poets and painters and so on and so forth. Well, who would be setting those examinations? Not the yahoos in the legislative branch. There was an examination branch, and then the election branch, which is an interesting thing, that there's a separate branch of government that controls the elections. Now, there is the problem of the infinite regress there, but at least it recognizes the difficulty of having the same legislature that is being elected determine the rules under which it was elected. But that's a piece of arcana interesting enough, and surprise your con law teacher with it sometime.
Thanks. So, like, given how little the Constitution actually says about election law, do you think the judiciary is the proper, like, venue for pursuing election reform? Like, if you look at the Warren Court's reapportionment cases, like, prescribing exact numerical equivalency between districts, given how little the Constitution actually says about how to do fair election, shouldn't that be something left up to the legislature?
Well, there is a lot of legislation. A very important body of legislation was enacted in 1971 and then importantly beefed up in 1974. We might call, that's the Federal Election Commission Act, and it is a monument to Richard Nixon. And that was a very stringent set of controls. The Supreme Court has been busily engaged in dismantling it. Citizens United is a dismantling of it. Buckley and Vallejo, to some extent, dismantles the 1974 legislation. A provision which I sought to defend in the Supreme Court and was one of my many Supreme Court defeats, McCutcheon, which had a limit on the overall money that an individual can give to all federal candidates. That's been there since 1974. The Supreme Court said that's unconstitutional just 2 years ago. 5-4. So, sure, there's room for legislation. What the court will allow is an important question. Professor Lessig, as you surely all know, has an agenda which consists of nothing but reform on these areas. Reform on campaign finance, and carefully designed not to run into any present Supreme Court decisions. Although, if it looks like it's too effective, they might catch up with him. There's that. He has very important lobbying reforms, and he has reforms of ballot access, which, as I cited to you, the Constitution specifically provides, unless the Supreme Court catches up to him. And also, he would reform the first-past-the-post system, all of which seems to be within the scope of Congress's power. But with this Supreme Court, you never can tell. It does seem that there are at least 2 justices, and on some occasions 5, who really think that any regulation of elections is illegitimate, even though I think that proposition carried to its logical conclusion is, merits John Adams's sobriquet is absurd. So that's my answer. And it's a very good question because it's before us. And that's what this election law series is going to be addressing. I might just mention who some of the people talking will be. On the 9th of October, Trevor Potter, who was a chairman of the Federal Election Commission and my losing co-litigant in the McCutcheon case, is going to be talking about I don't know what. but he is head of something called the Campaign Legal Center, and he's into it everywhere, legislative, litigation, and so on. That'll be very interesting. John Coates, whom you all know, John Coates, will be talking about the use of the First Amendment as a way to prevent regulations which should be allowed. And particularly, he objects to Citizens United, and he knows more about corporate law than any of us. Professor Tribe on November 9, and Professor Elhaig has a very interesting public choice theory, all of his own, which bring your computer and follow it. So these questions are really very much up in the air and worth considering. They have not been resolved. It's very interesting what Lessig is doing is he's saying, everything else depends on it. So I'm running for president. He doesn't have as good a chance as Donald Trump. I'm running for president just to focus this issue. And he will focus the issue. I read just today that that Hillary Clinton has come out with a lot of Lessig-like proposals, and we will be hearing it from others. So stay tuned. Yes.
Hi. Is that on? Great. There's loads of things I'd like to say about campaign finance because I've worked on a few elections in the UK, but I thought I'd actually change the subject. I just wondered, like, are there some positions that actually shouldn't be elected? Like judges. Coming from the UK, it's very weird to see judges being elected. And also in the UK, you know, over 50% of our legislature is unelected. And there are some good arguments in favour of that because they don't have to kind of throw themselves to the mercy of the public every 5 years. And sometimes they show a bit more leadership than the elected side.
That's a little abstract. Can you give me an example of how that would work?
Well, unelected people.
Yeah, well, unelected people who would do what?
Oh, so in the UK, you have the House of Commons, which is all elected, and then you have the House of Lords, which is entirely unelected. It used to be hereditary, but now it mostly isn't. And they play a major part in the legislative process.
Is that a system that exists somewhere?
In England.
Well, how does it work? Tell us.
So either side of the legislature can propose a law, and in most circumstances, the unelected side can override.
Oh, you're worrying about
frustrate.
the House of Lords.
Yeah, but I'm saying...
Oh, House of Lords, that's just a tourist pageant these days. It used to...
I couldn't disagree more.
And a way of paying off superannuated politicians. I
disagree.
That used to be, and in fact, our Senate was supposed to be kind of a House of Lords. Well, for the longest time, I forget when it was, the House of Lords could only delay, and now they can't even do that. I mean, they're really, it's more or less a body where they can comment on.
They can seriously
and the
frustrate
comment
stuff.
sometimes reflects public opinion and makes the actual operative house think again. Now you have a similar situation in a number of countries. For instance, in France and Italy, you have a Senate. And the senators are some of them are elected, but some of them are former prime ministers, sort of appointed politicians, and they too get to comment and may be able to hold things up. But
The Lords can initiate laws.
who can the
Members
Lords
of the House
can?
of Lords, yeah.
They can initiate laws. They can propose laws. It needs the House of Commons to enact them, doesn't it?
Well, on one argument, yeah, but similarly, the House of Commons can't pass a law without the Lords.
Well, that's not quite true. Because if the House of Lords does not give its consent and is stubborn on that subject, it can be ignored.
It's done it 3 times in the last 100 years.
I beg pardon?
It's done it 3 times in the last 100 years, or maybe twice.
Well, that's because they're damn careful not to do it. They know perfectly well that if they overdid it, they would be totally eliminated. And what they really fear is that their $200 a day allowances would be removed. No, I don't. I think the House of Lords is. You know Gilbert and Sullivan. When Wellington beat Bonaparte, as any child can tell, the House of Lords throughout the war did nothing in particular and did it very well. Well, that's the. Anyone else? Yes, good. I can't stay sitting. They gotta get on
Maybe
my
just
feet.
following on from the previous question, is there a sound normative basis for having a branch of the legislature not being elected?
Is there a sound basis?
Yes. I mean,
Well,
I
I
personally
don't-
disagree with the Lords, but is there sort of, from a
Well,
democracy...
like the House of Lords. Well, I don't know. I can't think what it is. I mean, how is it chosen? The House of Lords initially was hereditary. Now, there's a really unsound basis, right? Except, of course, it was a sound basis in the sense that those people also owned a large part of the land, and I make the case. I can't understand it.
Well, the case that is made, I'm not saying I agree with it, but the case that is made is that if you're not elected, you aren't subject to popular opinion swings
Yes,
as
that's
much as
the
you are.
argument against it.
Well, yes, of course, that's also the argument for it and against it, which is why you balance them out and have both. So you have one branch, which is always susceptible to populism, and you have the other branch, which isn't, which is sort of more focused on long-term, and yes, maybe there are $200 allowances.
Well, you assume more focused on the long term. Why not just say more focused on whatever interests them? That may be the long term, but it may not. I mean, if you assume, which I guess I'm prepared to assume, what the French Declaration and what John Adams and Rousseau and Locke thought, self-government, then I don't get the argument. And the argument you make is, well, yeah, the advantage is they're not responsible to the people. Well, I would have thought that's an argument against it.
But then let's elect all judges. So why isn't the Supreme Court of the
I
United
beg your
States
pardon?
elected? Then we can also elect all judges. Then let's elect the Supreme Court of the United States.
Electing judges is a really interesting case. When judges confine themselves to actually just deciding cases under the law, it seemed a very good idea. As a matter of fact, John Adams, in that same Declaration of Rights in 1780 said that judges shall serve for life and their compensation cannot be limited to the end that they be as independent as the lot of man allows. That's his phrase. Now, that phrase was dropped, but the federal Constitution picked up the structural point. The structural point is that the judges are not supposed to be making laws. So that's all right. They're supposed to simply decide according to the laws that have been made. Well, if you believe that, I'll tell you another. But nevertheless, that's the idea. Yes, ma'am.
Just slightly sticking with the English theme, sorry for non-English people. One of the major objections that some people have to the House of Lords is that it seems corrupt, that that parties and politicians are able to reward people for their loyalty to the party or for contributions by giving them a seat in the legislature. So a major objection to the House of Lords is that lots of party donors get appointed to the House of Lords. But how is that any more corrupt than a campaign finance system like the United States, where you effectively can buy influence over the legislature?
Because it is more frankly corrupt. Our system pretends not to be. Nobody quarrels with the notion that the way you get into the House of Lords is on the birthday honors list, and that it is major contributors to the party, senile politicians, stuff like, that's understood. It is debated, not very sincerely, but debated, that our elections are bought. That's the answer, the best answer I can give you. Yeah. Yes.
Could you speak a little bit about the original way that the Senate was elected and whether that might be something similar to what the English people were speaking about?
Well, that's the Senate was originally, senators were originally chosen by the state legislatures. So they weren't popularly elected. That's debatable. It is certainly democratic accountability, but at one further remove. And the framers intended it to be at one further remove. But it is still democratic accountability. Yes, sir. We need to get you a microphone.
I was going to say, what do you think about a current trend or argument for a form of e-democracy or a truer form of democracy rather than a Republican system where technology allows us to vote more directly on issues rather than depending on our elected representatives?
I'm talking to a man who's wearing an iWatch. Well, what do I think about? Gosh, I don't know. It's not.
It's a truer form of democracy.
It is a truer form of democracy in one sense, because you could, in fact, have a legislature consisting of all the electors. I suppose, the integrated online. My mind doesn't quite get around it. What about the deliberation? After all, what a representative body does is it puts a little distance between the voters and the result. In that distance, you can have debate and deliberation. Under your system, which has been, of course it's been suggested, and I'm familiar with it, it's scary. Now, but that may just be that democracy is scary, and that may just be your point.
Well, the representatives could do the deliberation and then provide what they want. Instead of them voting on it, they could present it to the people, and then we could, vote for it on our phone. So the deliberation is still there, but it's not them deciding. It's us making the final decision as a
On
people.
legislation.
That they've deliberated, that they proposed, and they present the proposal to us, the people.
Uh-huh. And this would be all legislation, not just a sort of a California-like sort of.
Some discretion could be used. I mean, it doesn't have to be every single, minute change to a statute or something, but things that are considerable and that affect us, I think, should be given more to people.
I'm at a loss for words, in the sense that it might be a wonderful thing. It's never been tried. We don't, it's never been tried. It's been tried a lot in California, as so many other things have been tried in California. It's been tried in California because so much of importance has bubbled up through the referendum system, direct democracy system. A lot of that which has bubbled up has been quite unfortunate. For instance, it took forever to have a reasonable finance system in California because by referendum that was blocked. But I can't give you an argument against it. There it is. Well, last question, and then we're going to stop.
We haven't really discussed the Electoral College quite yet, and I know that over the past 15 years or so, there's been, since Bush versus Gore in 2000, there's been a lot of discussion about the merits of the Electoral College, and certain states have begun to move in the direction of stating that they're going to allocate their electors based on the popular
Maine
vote.
now, and
Right.
I think, is it Nebraska or? Nebraska.
And Rhode Island, there's some discussion as well. So I'm wondering what you think about that trend, if it's going to continue or...
I don't know whether it will continue, but I'm trying very hard to think what a really good argument for the Electoral College is, and I can't do it. Thank you very much.